Next case that's set for oral argument this morning is City of Akron versus Kenji Lewis, case number 30166. Both parties are represented by counsel. Each of you will have 15 minutes to present your oral argument. The appellant may reserve up to 5 minutes for rebuttal. And as you know, time is kept on the clock, so keep an eye on the clock. I'll also interrupt you if you get close to Attorney Agrawal. Our arguments are recorded. They are also posted on the YouTube channel. Try to do that right away, but we also ask that you stay at the podium and keep your voice up so that the public gets a good recording. We would appreciate, and we have a rule that you're not to use the names of victims or children, if that applies in this case. Please otherwise refer to them. Judge Hensel, Judge Sutton, and I have read the briefs, and we are prepared to proceed. If you are, would you like to reserve some time?
I'll reserve 5 minutes, Your Honor.
5 minutes. All right. Attorney Agrawal, go ahead.
Thank you, Your Honor. May it please the court, Attorney Neil Agrawal for the appellant, defendant, Kenji Lewis. Thank you, Your Honor. The facts of this case is relatively simple. My client was charged with the M1 misdemeanor of the first degree domestic violence under not the state code, but the Akron Municipal Court Code. The day prior to trial, he filed through counsel a motion to dismiss for speedy trial. On the same day, it was denied, no explanation, no reasoning, no hearing, no testimony, no evidence, no record, just motion denied. The next day, my client entered a plea. Well, I will get to that, but there was a conviction for a no contest, supposedly, for domestic violence. And then there was an appeal. I got a point for the appeal, and that's what we're here for today. Your Honor, the first issue is the speedy trial calculation. And in my calculation, I calculated that the plea was on 91 days for speedy trial purposes. And the state actually corrects me and they say, no, it's not 91, it's actually 94, because one of the days that you calculated is out, he was actually in. So when you add 3 days, and I will concede that error, that he was actually in for 94 days for speedy trial purposes, and I thank the state for pointing that out. But they say there was a tolling event. They're not disputing that he pled 94 days after for speedy trial, but they said because there was a tolling, it was within the speedy trial calculations, and therefore it's not a violation of the speedy trial right. What was the tolling that the state is claiming is that one of their witnesses couldn't make it, it was on vacation, and the state asked for a continuance, and the court granted it. However, the problem with that argument is not that they asked for a continuance on the basis of a missing witness, but the issue is not that. The issue is what was the court's reasoning for granting the continuance. And I cite a Supreme Court case, State versus Van Coy, that says, it's State versus Ramsey from the Ohio Supreme Court. When the court grants a continuance under speedy trial, the court must enter the order of continuance and the reasons therefore by journal entry prior to the expiration of the time limit prescribed under 29.5.71 for bringing a defendant to trial. So when you look at the journal entry, it won't say motion to continue granted on the basis of a witness for the state is on vacation or missing or unavailable. It just says motion granted. So that is not in accordance with the Supreme Court precedent under the statute. And why do we do that? Because routinely, prior to this court decisions, the courts would just routinely say motion to continue is granted, granted, granted on behalf of the state. And there was no way for this court or the Supreme Court to say is whether those reasons were justifiable or, under those. Well, do we know if that's true? Was that accurate? Is that the basis? We don't know because the court is silent on the why the reason of continuance is granted. Because then you can never have a speedy trial violation because the state can say, well, if we're not ready for our case to go proceeding, we want a continuance, and the court doesn't just says motion granted. Again, what is the basis for the continuance to cause the tolling that has to be reflected in the journal entry? So I would ask you to look in the journal entry, and if there is no proper tolling, then he was tried 94 days outside the speed limit. Moving on to my second assignment of error. In this...
Counsel?
Yes, Your Honor.
With respect to that first assignment of error, the actual rescheduled trial date ultimately became September 27th, 2021, correct? Sound right?
That sounds right, Your Honor.
Okay. Does the record reflect whether or not Mr. Lewis objected to that 39-day difference between the original trial date of August 19th and that rescheduled trial date?
There's nothing in the record to indicate that. I think the trial court, after it granted the continuance, as far as I can tell, just set a new date. There was no input from the defendant or the state, as far as I can tell. And I cite case law that says a defendant does not have to object if the state sets it outside the speedy trial time limit, because the indolence of a speedy trial violation is incumbent upon the trial court and the prosecution to make sure. A defendant doesn't have to come to the court and say, this is violating my speedy trial, speedy trial, speedy trial. I want a trial date earlier. The state and the prosecution and the court is supposed to know what is the speedy trial date and to ensure it. And there's no basis to say that he had to object to that speedy trial date. And then finally, they also say, as far as the speedy trial is, that since he filed a motion to dismiss on speedy trial, that counts as a one-day tolling. And I cite case law from the Ohio Supreme Court, again, State versus Long, that says filing a motion to dismiss does not in itself cause a speedy trial stopping or resetting and all. And the state in response says, the case Mr. Lewis cites, anticipation of this argument, State versus Long, deals with a different procedural context and does not bind the court here. Now, I might have been in law school and I slept a lot through law school, but I can never remember where they said Supreme Court decisions are not binding on this court. They may not be applicable or whatever, but to say it's not binding, I don't understand that whatsoever for the state to say, we don't like you to apply this decision from the Ohio Supreme Court as it's not binding, which is really flabbergasting. Moving on to my second assignment of error. On this day, the defendant was before the judge, and the judge asked the defendant's counsel, is your client going to plead no contest? And the defense attorney says, yes, Your Honor. And the judge says, okay, I'm going to impose a sentence of $150 fine, and you have to do these classes, and things like that. At no point did the trial court ask the defendant himself, do you wish to enter a plea? Or what is your plea? Is it no contest? Is it guilty? Can you give me some affirmative statement, one way to answer? How are you pleading guilty, or how you want to enter? And the state concedes that argument. But their argument is, so what? So what if the defendant didn't himself plead guilty or enter no contest plea? His counsel did. And that's good enough.
Well, their argument is substantial compliance, right?
Well, that's for the plea colloquy, and I'll get to that. But as far as the actual plea, they're saying the fact that his counsel said he was going to enter, that's good enough. The defendant himself does not need to enter a guilty plea. And they've cited I can't find anything case law that says asking your attorney what his plea is going to be counts for anything. In fact, this court has said the exact opposite. You have to ask the defendant, and he has to personally state on the record what his plea is going to be. Now, they say there was substantial compliance with the plea colloquy, and I'm arguing there wasn't, and I said it inartfully, there was no valid waiver of his rights, and the state said, no, that's not true, there was. And that is true, but what I should have said is, there's not a valid waiver because it does not comply with Criminal Rule 11b2. And in what way is it defective? When you look at the plea, under paragraph 11 of the plea, a plea of no contest is admission of the truth. It goes on to say, such a plea cannot be used against me in any future civil proceeding. That is not in accordance with Criminal Rule 11b2, which specifically says, a plea of admission shall not be used against the defendant in any subsequent civil or criminal proceeding. So the state's waiver form, or the court's waiver form, does not comply with 11.2, does not in any way say if this would be used in any valid criminal proceeding. And the state says that the mere language complies with Criminal Rule 11. It does not. And then lastly, for the second cycle of error, is the state concedes that at no point did the trial court say, based upon your attorney's plea of no contest, I'm going to find you guilty based upon the facts and circumstances. That never happened. And I cite case law in the statute and the rule that says in muni court, the trial court has to say, I'm making an admission of finding of guilt against you. So that was never done in open court. So the whole plea is the fact that the plea colloquy doesn't comply with criminal rule 11C. The trial court never asked the defendant himself how is he pleading, and the court never made a finding in open court on the record that he was guilty of anything. And then lastly, the trial court imposed a sentence upon the defendant, but at no point did he enter in a colloquy with the defendant asking, hey, do you want to say anything in mitigation of sentence? Do you want to say anything before I impose sentence? Nothing like that. He asked the defense attorney who made an argument, and then he asked the prosecutor, but what did he ask the defendant? It's absolutely nothing. And again, the state concedes that argument, but again, their argument is big deal. The state gave, the judge gave a nominal sentence, and therefore you can't show harmless error. First of all, it's not a nominal sentence, because the court imposed, he's to take classes, gave him a fine, ordered him to have no contact with the alleged victim. We don't know if the court would have done any of that. It wasn't just a minimum and then imposed court costs on top of a fine. So how is that a minimal sentence? And in any case, there is not a harmless error, because it wasn't like the defense attorney said, oh, my client is, I advise of counsel, he's not going to speak, he's not going to say anything in sentence, anything on mitigation. The trial court just didn't do it. And I cited case law out of this court that says that it is not an empty ritual. It's not just simply say, oh, you have anything to say? No, okay, here's your sentence. I mean, this is their last chance to express the remorse. It's their last chance to say the circumstances that led to the offense. It led them to say, please don't impose a court fine for hardship, or I can't do these classes, whatever. It's his chance to give it, and his 2 cents to have a sense that he had a fair say in sentencing, and that was never done in this court. So based upon all that, I would ask the court to reverse this conviction and remand. Thank you. Court dismissed.
All right, thank you, Attorney Agrawal. As you can see, you have 3 minutes and 53 seconds.
Thank you, Your Honor.
All right, Attorney Walsh, 15 minutes.
Your Honors, may it please the court. My name is Mike Walsh. I represent App.No, the City of Akron, in this appeal from the Akron Municipal Court. As Mr. Agrawal said, this is a pending misdemeanor prosecution for domestic violence. Although there are 3 assignments of error, it really breaks down into 2 issues in this case. First, whether Mr. Lewis's speedy trial right was violated, and second, whether the trial court complied with the criminal rules in plea and sentencing. I'll work in that order. First, on speedy trial, as both parties concede, more than 90 days elapsed from date of arrest until date of conviction on September 24th of 2021. So as opposing counsel stated, we have to look at tolling events. Now, opposing counsel concedes that the state moved for continuance on August 13th and that the court granted a continuance on August 17th, 2021. And opposing counsel makes the point that the court never reasoned its continuance, and therefore that's enough to say that the continuance was not for a reasonable purpose or a reasonable length, but that actually is not what this court's precedent states. This court in Roth stated that when a court improperly, will admit, does not explain its reasoning for a continuance, the court will look to the record and to any filed motions asking for the continuance to determine the reason, the reasonable purpose and the reasonable length, adopting the test for whether a continuance complies with the 2945.72H tolling standard, or that was this test from this court in Berner interpreting Lee. Just from Berner, rather. Sorry. So on that August 17th continuance, the reasonable purpose was victim unavailability, prosecuting witness unavailability. They were one and the same in this case. It also happened to be the only eyewitness. Now, the Ohio Supreme Court in Safel and this court in Roth and Berner have stated that a continuance to allow a victim or prosecuting witness to be present for a trial is reasonable, sufficient to make that continuance a tolling event under 2945.72H. And that gains more support from Marcy's Law, which was passed since those cases were introduced, and makes it a constitutional obligation for the state to allow a victim to be present at trial if they so wish. And as for length, and here, as Mr. Lewis's attorney concedes, there was never an objection to the length of the continuance. And per this court's precedent in Berner interpreting Lee, that alone is conclusive evidence of the reasonableness of the continuance.
I think Mr. Agarwal cited Ramsey as controlling, saying that the basis for the reasonableness must be in the entry. Is Ramsey good law still or not?
I believe Ramsey is good law, Your Honor. However, I do believe that, if I recall correctly, Roth, which is from 2018, postdates Ramsey.
Well,
Yes, 2018 Ohio 2564. Mr. Lewis also does not address the third tolling event that the city identified in its brief, which was the initial scheduling order, which was issued by the court on June 25th and continued the case until July 7th. That order contained everything that Mr. Lewis alleges that is improperly not in the August 17th continuance. It explains the reason for the continuance, that being court unavailability because of the COVID-19 pandemic. It includes very clearly the instructions for service, and I believe it has a CC at the bottom that Mr. Lewis's counsel at the trial court was served with that document. And it states that, and it's a very clear continuance by journal entry. So to the extent that Mr. Lewis's complaints about the August 17th continuance is solely, as he said here, that the court didn't explain the motion, then certainly Mr. Lewis does not have a complaint about the initial scheduling order, which ran for 12 days from June 25th to July 7th. And as all parties concede, the 12 days there is enough to push the end of the 90-day clock past the September 24th plea, bringing this case into compliance with the speedy trial statute. And as for the September 23rd motion to dismiss, the distinction here is a motion to dismiss for speedy trial that's filed inside the speedy trial period does toll the speedy trial clock. That's from this court's precedent in Rapucci, Hollander, and Zerati. And that is a distinction drawn here. The case law Mr. Lewis cites is for a motion to dismiss that is filed outside the speedy trial window. That is, the defense does not somehow resuscitate a prosecution that's untimely by filing a motion to dismiss after, in this case, 90 days. But this court has stated previously several times that when a motion to dismiss for speedy trial is filed prematurely, that does toll to allow the state time to respond. In this case, that would only be 1 day, and as both sides are now conceding the city's calculation for brief is correct, that Mr. Lewis is actually correct now, that September 23rd motion to dismiss would not be a tolling event, but for the other tolling events, which already pushed the time past. Moving on to the issues with the plea hearing and sentencing hearing, the city certainly would not say that this was a perfect plea hearing or sentencing hearing. I think that's fairly apparent from the record. However, this is certainly not an instance of complete non-compliance. Every single complaint that Mr. Lewis raises, whether appropriately or insufficiently in his brief, they've had some level of either partial or substantial compliance. First, even accepting Mr. Lewis's argument that the waiver of rights form that was signed on multiple places, or initialed or signed in multiple places by Mr. Lewis, is improper, is still certainly substantial compliance. If it's at all wrong, it's an inartful statement of the rules, and we'll certainly look into that. But it still shows that Mr. Lewis was informed of the substance of his criminal 11B, of the criminal 11B language. And as Mr. Lewis indicated that he understood his rights, there was no prejudice here. The test for prejudice on the criminal 11 issues is whether the plea would have otherwise been made. That's from the Supreme Court in Nero. And here it's fairly obvious that Mr. Lewis intended to plead no contest, as he indicated evidently to his attorney who entered the plea, and on the waiver of rights form where no contest was circled and Mr. Lewis signed.
Isn't that the value of the interaction between the court and the defendant, this oral interaction? He may not understand what he's signing, or he may be pressured into signing a document. That's why we don't just accept the written waivers, perhaps, and that discussion is important.
Certainly, Your Honor, and as I said, I would not call this a perfect plea or sentencing by the trial court. But if I recall the sentencing transcript correctly, Mr. Lewis was asked by the court whether he understood the rights that's been read to him by his attorney. I believe Mr. Lewis's argument here is that the trial court did not fully go through the list, so it's unknown what Mr. Lewis's counsel might have or might not have said to him. But every indication in the record is that Mr. Lewis knew what he was doing by pleading no contest. Yes, and certainly that's sufficient under substantial compliance and the lack of prejudice. On the verbal plea, Mr. Lewis's attorney did enter a no contest plea, which is not in compliance with the rules, but it's certainly substantial or at minimum partial compliance, because there was still the question of how do you plead, and someone representing Mr. Lewis said no contest. That combined with the waiver of rights form shows that there's, again, no prejudice. On guilt in open court, Mr. Lewis's counsel below did stipulate to a finding of guilt. So again, perfect compliance? Absolutely not. But was there at least partial compliance? Yes, because the court acted on a stipulation by Mr. Lewis's counsel. And based on that stipulation, again, there could be no showing of prejudice. And on allocution, then I don't believe this court has ever firmly said this, but many of the appellate courts in this state have put out two examples of when there's harmless error, or two factors rather, for finding harmless error in a lack of allocution. First is when the defendant's attorney is allowed to speak by the court, and second, when there is a minimal sentence, not nominal, minimal. That's from Reese in the 6th District, which we cite in our brief. And in this case, Mr. Lewis's attorney was allowed to speak, and she did speak rather eloquently on his behalf, giving a very good reason for going to a lesser sentence. She spoke on Mr. Lewis's compliance with pretrial orders, which we certainly applaud Mr. Lewis for. And then as for the sentence, it's worth remembering that the sentence handed down by the trial court was substantially similar to the only plea offer sheet that exists in the record. Both called for a $150 fine and court costs. The trial court here actually did Mr. Lewis a favor by crediting time served both for the non-suspended jail sentence and for the fine rather, which takes not insignificant though not massive amount of money off for the 2 days spent in jail. 108 days in Summit County Jail with 178 suspended and credit for 2 days time served. On the condition that he obey a loss for 1 year, or that the plea offer sheet that's in the record, which is worth noting, exceptionally predates the plea, and I don't know whether this was the one that was used or the one that was used, just never made it back in the record, but this is the record we have before us. The plea offer sheet asked for a bail loss 1 year, a summit link, and anger management class. Summit link being an evaluation for drug and alcohol use, and no lawful contact with the victim. What the court did instead was anger management and parenting classes for Mr. Lewis, which is debatable whether it's different or how different it is, but based on the record we have before us, it's arguably about similar. It's 2 classes. There's probation until he completes the classes and no lawful contact. It's a very similar sentence to what Mr. Lewis, based on the record before us, would know he was getting into. And certainly for a crime like domestic violence, I think most people would say that 2 days in jail and completing 2 classes is a minimal sentence. If there are no other questions, for those reasons, the city asks that this court affirm in full. Thank you.
Counsel, I do have this question. Just on that point that is raised by opposing counsel regarding that the defendant, the guilt of the defendant was not stated in open court, that wasn't stated under grace, the case grace. Could you just speak to that for a moment?
Certainly, Your Honor. Should the pronouncement of guilt come in open court?
Yes.
Absolutely. We don't contest that that's what should have happened. But in this case, the pronouncement of guilt in open court is still under the criminal rules, which allows the substantial or partial or no compliance analysis. And here, the court was acting on the trial, Mr. Lewis's trial counsel's stipulation. The trial counsel stipulated that Mr. Lewis would accept a finding of guilty in this case. And with that, under Harris, pardon me for a second. Under Harris, from this court's decision in Harris from 2018, there is a necessity to show prejudice on a failure to announce a verdict case. And here, because Mr. Lewis's counsel stipulated to the finding of guilt, there's no prejudice. Should there have been a pronouncement of guilt? Absolutely. I can't argue that there shouldn't have been, but there is a need to show prejudice when there's not, and because Mr. Lewis's attorney stipulated to a finding of guilt, there's no prejudice here.
Just quickly, was there a objection to the length of the continuance when the court continued the trial?
No, Your Honor.
Okay, Counsel, do you? All right, thank you.
Thank you.
Attorney Agarwal, 3 minutes and 53 seconds.
Thank you, Your Honor. May you please the court. Just a couple of points. If you go to page 13 of my brief, the last paragraph, where I talk about that Mr. Lewis never entered a verbal no contest plea, I cite a recent case out of this court, Speedy versus Johnson. And there the court reversed the conviction because Johnson there never entered a guilty plea to the petty offense in open court. Then I cite a case out of the 8th that reversed the conviction because there the defendant did not enter a no contest plea to a petty offense at any point. Then another case that Cleveland versus Paramount Landings that says at its most basic level, the courts failed to comply with Criminal Rule 11 because it failed to even take a plea of no contest from the defendant. So the purpose of the plea colloquy is we don't know what the defense attorney has told the defendant or if the defendant's competent. Is he on drugs? Is he on alcohol? Does he have a wherefore of what he's doing, what's going on? And the person who's supposed to determine that is the trial judge. And the way you do that is you engage with the defendant. You ask him, do you understand your rights? Do you understand what a no contest plea is? What is your plea? Here, the state is saying asking the defense counsel is good enough. How do we know what occurred between the defendant and the defense counsel? We don't. We don't know if he got good advice. We don't know if he got bad advice. It's not the duty of this court to figure that out, because it's the duty of this court to determine that the trial court engaged with the defendant adequately and explained to him his rights. So there was no plea. They keep saying his counsel will enter a plea of no contest. Well, what if he didn't want that? We don't know, because the defendant was never asked by the judge. I mean, it's a one sentence, it's a one question thing. It takes literally 5 seconds. How do you wish to enter a plea, Mr. Lewis?
How does that square with the written plea agreement or the waiver of rights?
Waiver of rights and plea are two separate issues, Your Honor.
I guess I'll have to take a look at what he signed.
Yes, yeah, fine. But again, as I pointed out, and the state's not even disputing here on the oral argument that the plea form itself is defective. It doesn't comply with Criminal Rule 11. So if you're going to say you have to explain to him what it means to enter no contest plea, was he ever explained that it cannot be used in any future criminal proceeding? It's not in the form. It's not on the record. It's mandated under Criminal Rule 11. So where was that compliance? And then to say, well, he knew what was going on. How? By the judge not entering a finding of guilt? At no point did the defense or the judge say, I now find you guilty. I mean, if the defendant had no other inclination, he'd be waiting for the judge to say, I find you guilty, and then he could object or like, okay. But here, the judge kept quiet because, again, it was a hide the ball game. We're not going to give him his rights. We're not going to tell him ask him if he's pleading guilty, and then we don't even say we find him guilty. Nor do we even ask him, what do you want to say prior to I sentence you? So this whole thing is defective on so many levels, I don't even know where to begin. So I'd ask the court to look at the transcript itself is only like 5 pages. So that's how nominal the judge put effort into this case. And I understand, it's a misdemeanor, but everyone's entitled to due process, and the judge should have inquired adequately. So I'd ask the court to reverse and vacate and remand. Thank you, Your Honor.
All right, thank you, Attorney Agarwal. Very good arguments. Interesting case. Thank you both for being here today and presenting those arguments. We'll take the case under advisement, issue a decision in due course. Of course, you each will receive a copy on the day it's released from the clerk's office, and the opinions are posted on the Supreme Court of Ohio's website. Thank you again for coming down and giving us
Thank you.
Very good arguments. Thank you.